What's he doing? He was for some small
Is the court ready?
Yes, thank you.
Court ready.
Court rise if able.
My Lords, before we move on, I think the reference that my Lord Justice Arnold had in mind about the asymmetry, which we weren't able to put our finger on at the time in my Lord's judgment in Trial F, so it's Authorities Bundle 3, Tab 2, is actually paragraph 36 on page 99 of the bundle, and that identifies the asymmetry as the effect of delay being much more common to set owners, so the licence always.
Sorry, did you say 32? Sorry,
36.
36.
36. It's tab 2, page 99, and it's the paragraph. I think paragraph 36 is the one that my Lord had in mind.
Yes, I see.
Well, we were on the very last paragraph in the annex to, paragraph 9 in the annex to our skeleton, annex 3, and I was going to move on to show, my Lords, how that particular extract was dealt with in the cross-examination, and that's actually set out by the judge.
Just incidentally, I'm not sure it matters, but I assume you wouldn't dissent from the proposition that that's res judicata.
What I've just shown you?
Yes.
Yes. No, I wouldn't dissent.
I think you would rather rely on that.
Yes. Well, it's actually more, even more, as it were. You know, that's well known in the. I think even that passage suggests that it's well established in the Supreme Court of reason.
What? Yeah, but the point is that although I say it was consistent with the view expressed by the Supreme Court, the point is that that was a finding of fact by the trial judge in these proceedings.
Sure, absolutely.
Based on expert evidence.
I agree. It is these proceedings. It's not.
So Hollington-Hewthorne doesn't arise.
No.
It's these proceedings.
It is these proceedings.
And it's res judicata.
These proceedings were split up into separate trials of different issues, but my Lord's absolutely right. These proceedings. Now that last extract in paragraph 9 as to what was said was subject to cross-examination, which the judge set out on page 373 of the judgment. And you'll see the substance of the point that we saw in paragraph 9 of the annex is repeated in my first question. And Miss Muse repeats the same point that they made offers anyway. And I ask her what that's got to do with it. She repeats they made offers, and in the middle of the page I suggest to her that they knew the position they were taking was untenable, and it is untenable to refuse to agree they needed a licence to any Ericsson patent at all. And of course it's being done to avoid having to get a licence determination. And I asked Miss Muse if Apple actually believed it. The answer is this: it was important to recognise they could be wrong, and she suggests the reason for the offers was on the assumption they were wrong. And by the bottom hole I asked whether Apple actually believed it didn't need a licence. The answer was we, i.e. Apple, had reasonable positions. So pausing here, Miss Muse is only going so far as to recognise they might be wrong, but suggesting they had reasonable positions. And the essence of this is that Apple suggesting that they did believe it, at least to the extent that they thought there was a reasonable basis for it, even though they may turn out to be wrong. And they certainly did take that position vis-à-vis Ericsson. And the letter that we've seen the extract for specifically recorded they refused to agree they needed a licence to even a single patent. Now if we read on in the passage that the judge quotes on page 374 at the top of the page, They say it's an untenable thing to say, but they do say it. The answer's the same, but they made offers. So I ask, is it okay to lie to them if they made an offer? And the answer is they, Ericsson, don't admit the portfolio may include invalid patents, may include non-essential patents. She says it's the same for Optis. And I have to say, I'm not quite sure what she has in mind, if she's suggesting Ericsson or indeed Optis or any other SEP owner make claims that if litigated they will or could achieve a 100% success rate on the entire portfolio. I suspect what she's really saying is that no specific patents are identified as ones they accept ex ante they're bound to lose on. But of course that's another point entirely to the one that I was exploring with her. While we're here, my lords, subparagraph 4 in this section refers to the heat in these negotiations, which the judge remarks features in other negotiations too. Put shortly, Apple upset everybody like this. The sums at stake are just too high for it not to pursue this blueprint or holdout. Now, my lords, can I turn back to page 371 and 372 because I jumped over a passage of the judgment with the judge's commentary and analysis between these extracts. So it's the passage at the bottom of 371, top of 372. At the bottom of 371, you see the judge said my suggestion of bad faith, not just as regards Ericsson, he says Optis, but he must mean Ericsson, not just with them, but generally, and indeed that was what I was suggesting. And he said the case never came close to being achieved. And what the exchange he set out demonstrates is hard-fought but not unfair negotiations between two large corporations. And he refers to what each side were seeking to achieve, some of which I think is glued out, so I won't read it out. But then right at the foot of the page, 371, he says Apple was perfectly entitled to, one, point out there were high invalidity and inessentiality rates in SEPs. Pausing there, yes, agreed. And at the top of 372, two, to note that Apple had not been found to infringe any SEP. Pausing there, not so if what's actually being conveyed is patent by patent approach and contention that no licence at all is needed. Third, the judge says, if Ericsson chose to litigate, Apple would defend itself. Pausing there again, at the most basic level, of course this is so, but most certainly not so if that may mean that it's not submitting to an appropriate FRAN determination and that it's going to engage in requiring the litigation to be patent by patent. My submission, the judge is just not engaging with the reality of what's going on here by saying those three things do not amount to impropriety. And it rather looks again like what he's really looking at is whether any of this is per se unlawful, but that's not the correct prism. Because holdout is of course not per se unlawful, else you could stop it. But in a FRAN context, the second and third things the judge identified most certainly do amount to impropriety if the detail of how it's done amounts to a patent by patent approach and refusing to submit to an appropriate FRAN determination. And, well, I can also draw attention to the fact that we can see from footnote 359 that the judge is specifically considering the patent by patent approach. We see he refers to it being, prior to the Unwide Planet Supreme Court decision, and in fact still the case in many jurisdictions, open to an implementer to oblige the SEP owner to litigate every patent in every jurisdiction. He says it's not particularly efficient, a massive understatement I would suggest, and may not amount to oppressive conduct, another massive understatement I say. But he goes on and says this, but taking such a course or threatening it in the first instance, something that an implementer is entitled to do, and refers to Miss Muse believing that. It's simply wrong. It's inexplicable in my submission. Of course they're entitled in the sense that there's little or nothing that the SEP holder can do to stop it. There's no law against it, you don't go to jail for it, and there's no existing obligation that you can be sued for a breach of. But that's why it's so pernicious. Apple is not entitled to do it in the sense of acting fairly and properly within the FRAN framework. That is the blueprint for holdout. But the judge is saying the implementer is entitled to adopt it. It simply can't be right.
So, rephrasing your point in different words, what you're saying is that the whole point of the FRAND obligation is that it is a constraint upon, I think the word the Supreme Court uses is derogation from the patentee's normal entitlement to enforce by injunction. Furthermore, the whole point of the obligation of good faith is, which applies under French law in this context, is that it is a constraint upon a party's ability to act solely in accordance with its own interests.
That is right as well, my lord. But I was making an even more basic point, assuming that there isn't any French law obligation that might bite on them, but the FRAND framework that's been set up requires you to be doing things and operating in a way where there is no other legal obligation to force you to do it. That's the whole point. The whole point of Lord Kitchen saying it's important that implementers submit to a FRAND determination, an appropriate one, is because he realised that actually there's nothing to force them to do it. And it's just not operating, it's not playing by the rules of the game that the FRAND system is concerned with by just saying if there's no other law against it,
it
it's
works
fine.
both ways. So the FRAND obligation is a constraint on the SEP owner, but by the same token, it's also a constraint on the implementer.
Well, yes, in this regard, my lord, if you want to come into the system and have the benefit of it, you have to play by the rules.
Yeah.
And we'll see later that what the judge is basically saying is that there's nothing on the illegitimate side of the line is legitimate, illegitimate hold-up. And you can see it's basically this view that he expresses in this footnote. And I'll be listening very carefully to hear my friend's answer as to how this footnote doesn't portray a complete muddle on the part of the judge as to what is legitimate or illegitimate. He's just got the fundamentals of the issue being debated before him wrong.
Mr. Speck, is this just trying to think about your point? Is this a similar point, or even the same point, as the question that's arisen in some of these cases about the boundary of what is or isn't FRAND being not the same as the boundary of what is or isn't anti-competitive?
It may be.
In other words, what I'm getting at is, if you take the view that FRAND behaviour is the same, the boundary of what is or isn't FRAND behaviour, at least from the point of view of the SEP owner, is the same line as anti-competitive behaviour, then, for example, it's hard to see how you could ever make an offer which was a bit too high, because then you'd be, if it wasn't a FRAND offer,
Sure.
you would be anti-competitive. And at least as far as I understand it, the position is that's not the correct analysis. It is not the case that an offer which is higher than FRAND is necessarily anti-competitive, and the same goes the other way around. In other words, whether something is FRAND or not isn't the same question as whether it's contrary to the law.
Exactly, certainly.
And ultimately, therefore, you can perfectly legally enter into agreements which are not FRAND. So in that sense, it's perfectly legitimate. But the question then is, what is the relevance of an agreement of that kind if you're trying to work out what is FRAND?
That's absolutely right. But also you can behave in a way, because FRAND is more than just
Yes,
the
yes,
agreement.
it's behaviour in a way.
It's behaviour as well. You can behave in a way which is lawful because nobody can stop you doing it, but it's not FRAND and it's not proper when viewed through the prism of FRAND.
Or maybe the word proper is where it is unhelpful.
Well, okay.
It's not FRAND.
Not FRAND.
And as my lord says, the real question is what significance you attach to comparables.
That's where it feeds in, because the effect is they've done this in the past. In fact, we say they were doing it to us in this case, but they've done this in the past, and they're relying upon a whole body of comparables which have been secured through this, which the judge says they were doing to soften these people up. Now, returning to the body of the judgment text, so 4 lines down on 372, the judge then addresses the fact that neither party could possibly have believed that if each and every one of Ericsson's sets was litigated, either would win on 100%. We agree. He goes on to say that to expect either to concede ex ante that a given patent or a proportion of the patents was invalid or valid would be ill-advised. Please pause and note the insertion of the word "a given." Of course you wouldn't expect a given individual patent to be identified and agreed. definitely invalid. But much more than that is going on when an implementer refuses to agree it needs a licence on any patent at all. It's in substance asserting that it has a position that it will or might win on all, as we saw Miss Muse realise in the cross-examination. She answered the questions on the basis they had a reasonable position, the inference being that they could take the extreme position because it could happen was a reasonable prospect. Now, my lords, if we pick it up about 7 lines from the end of this paragraph, we see the judge says that what it is possible to say is the suggestion that Apple honestly believed not a single patent in Ericsson's portfolio was being infringed by Apple verges on the ludicrous. We totally agree. I was obviously not putting my questions to suggest that they did in fact honestly believe it. My point was precisely the opposite. And the judge goes on and says, Apple never believed it. Again, we totally agree. But then he says this, and never suggested it. Well, what is refusing to agree that they needed a licence for even a single patent, coupled with a suggestion, as Miss Muse put it, that they had reasonable positions on all of them? In substance, precisely this, which the judge said was ludicrous and something Apple didn't believe. Can we go forward to where the judge deals with the actual question of holdout? It's a very brief passage at the beginning of the section on assessing lump sum for the stack on page 480. We saw it yesterday. It's located here because the judge is addressing the question of whether the Apple comparables were holdout licenses. And the first point I want to make is a point. This is the point in my note where I was going to make the point that I made to my Lord Justice Arnold earlier. The judge never asked himself the question of Apple holding out more generally, specifically the issue that my Lord indicated you anticipated would be decided in this trial, whether Apple was guilty of holdout in its conduct in these very proceedings. But he did, as I've already covered, hold that Miss Muse was unable to provide justification for the way they conducted them. So my suggestion to my Lords is that the answer to that question, had the judge addressed it, was obvious.
Mr. Speck, can I just make sure I got the timing right? The judgment of the Court of Appeal in Trial F was after the trial of this trial, wasn't it?
No, it was before.
It was before the judgment, but I thought it was after the trial.
I'm not actually. Off the top of my head, I can't say. Certainly, the Mr. Justice Mead decision, I think.
No, I agree. I think Mr. Justice Mead's decision was before the trial, before Mr. Justice Marcus Smith. But I thought the Court of Appeal in Trial F was after the trial.
That may be true.
But I'm not
That may be
certain
true.
about that. I can see some knowledge.
But I think the judgment was out before this judgment came out. So.
Right. No, sure.
Yeah, so that it's correct. I've checked the dates. So Mead's decision was before the trial and the Court of Appeal after the trial.
And my lords, I don't make the submission that just because if holdout was happening here, it means other licences entered into with others were necessarily also achieved by pursuing holdout. But it would shed light on it in my submission. Turning to what he did address, as I mentioned yesterday, he dealt with this major issue in just 3 sub-paragraphs on page 481. In fact, only really 2, because the first one simply identifies the point. And he says he's not accepting our contention at the beginning of sub-para 2. And he goes on to say we never came close to differentiating between legitimate bargaining and illegitimate bargaining. And he says every effort to fight its own corner is an essential part of any market economy. And he says that we labelled every effort was labelled holdout, which he says is not a sound approach. Now, just pausing here, my submission is there is a world of difference in saying any effort to fight your corner is holdout and saying your strategy involves taking objectionable stances which are holdout, indeed what have been previously identified as the blueprint for holdout, and because you do it every time, all of your negotiations are tainted by holdout, which is what our position is. If an implementer has an honest disagreement, they can fight that dispute vigorously in ways which do not involve deliberately avoiding or delaying it being determined. They can, as Lord Kitchen said in this court's decision, submit to an appropriate Fran determination. As we've seen, Apple disagrees with what Lord Kitchen says, and actually the substance of footnote 359 that I've shown you is the judge disagreeing with what Lord Kitchen says. Reading on in subparagraph 2, we see that what the judge really means. He said very early on in the judgment, he said it'd be necessary to consider the difference between legitimate and illegitimate holdout. That is paragraph 20 earlier on in the judgment, just for your note. And that, if we just turn it up, you'll see has footnote 25, which we'll be coming on to, which records Apple's attempt to change the findings of primary fact. He records what happened afterwards, which I'm going to show you in a minute, but that paragraph 20 is the reference to early on in the decision, in the judgment that he makes in the passage that we're on page 480. And it's plain there he's talking about country by country and patent by patent. So, returning back to 480, we're in the middle of subparagraph 2, and the judge says, in substance, we, Optis, have failed to identify an illegitimate holdout and has actually depressed rates, although I'd add this. That's obviously the reason it's done. And what he's actually doing here is obviously he's come to the conclusion that it has to be illegitimate, and he doesn't actually think anything that they've been doing is illegitimate at all. He says we didn't coherently articulate any difference between legitimate and illegitimate holdout, and as a consequence he says our case is insufficiently made out. And it looks like we've lost on a burden of proof point for not articulating a distinction that we say doesn't exist. My submission today is there's only holdout conduct, and that's what an unwilling licensee does to avoid or delay taking a FRAND licence, and avoid or delay having it determined, and that is illegitimate.
Maybe asking a question I asked you a minute ago, Mr. Speck, but why does it matter whether it's illegitimate?
Well,
I wondered what you were going to say, so I thought I'd wait until you said it, but you did say it, so I think it's a fair question.
it only matters, actually, my lord, that's a fair question. It only matters because the judge thinks there is this legitimate or illegitimate distinction.
Okay.
And actually, my lord's right. The substance of my submission is really there is no such dichotomy. Holdout is illegitimate in the way that I've said. It's not playing by the rules of the game, so it means that it's not FRAND.
Right. Thank you.
Now, as I've already foreshadowed, the judge also appears to think there's a timing thing, and I say that because the judge says Apple negotiated properly at the end of subparagraph 2, but it's also a conclusion plainly based upon his view that there's this legitimate and illegitimate holdout. And he seems to be saying in the next paragraph, it wouldn't be legitimate today because of the Supreme Court judgment in Unwired Planet. Seems to be suggesting that. But in my submission, conduct that is holdout is conduct that is holdout. You don't need the court to have pointed it out. And in fact, this court had already pointed that out before the Supreme Court decision. He says in subparagraph 3, identifies a series of aspects he's considered, which he says isn't right. He refers to patent by patent. But then he says all these points were bad, at least at the time they were made. But he doesn't consider them to be badges of illegitimate holdout. And then he goes on and says he considered Apple was perfectly entitled to advance all of these points at the time. Again, reflecting his footnote 359, which seems to suggest that things have changed after the Supreme Court. And he specifically goes on and says he doesn't have to decide about the future. In fact, he does, because some of the licences were afterwards. But the thrust of what he's talking about here is that somehow things may have changed and that conduct that in the past was okay might not be now. But in the context of working out whether it was frowned and whether it depressed licences that he's looking at, that can't matter at all. Now, can I address how Apple seeks to deal with this issue?
Just before you do, I mean, I see that the judge dealt earlier with hold up and hold out in paragraphs 365 onwards. Do they take things any further?
They do in that. If you go to 369, that is the section that I drew attention to yesterday, where the judge has got that rather startling heading about it's prima facie legitimate.
I mean, he says in 371, I don't go so far as to say that hold up or hold out can never be illegitimate.
Yes.
But in the ordinary case,
Yeah.
they're normal manifestation.
Yeah. And so what you've got is more of the same there, and it's quite a startling heading. Certainly when I looked at that, I thought, how can that be so? But you've got more of the same with him. What you see there, my lords, is perhaps the essence of him thinking, if it's otherwise lawful, it's all fair game.
I mean, he is a competition lawyer. One probably sees the impact of that.
Yeah, yeah. Now, I was just about to move on to how Apple seeks to address this issue, and we need their skeleton from paragraph 87 onwards. And this is a section where my friend says there are two answers to my submissions. The first argument, which is the principal one, is an argument that I'm eliding the judge's findings. And the second is the suggestion that my Annex 3 of the skeleton was selective, and I think they say it was engaged in island hopping. Can I deal with the first point first? It's dealt with from paragraph 87 through to 95. And if we jump right to the end of it, the summary, their point is that they say we disregard the difference between conduct found by the judge and the conduct that was deprecated by this court in unwise planning. So the point is that they say there are two different conducts, and we, Apple, say not having regard to the difference. And this point is actually purportedly split into two within these paragraphs, but in reality it's the same point. And key to it is seen back at paragraph 88 on page 170 of the bundle, where Apple argues there are two different practices which we're eliding. And the first, I've already foreshadowed this right at the outset, they say is in the course of negotiations informing the counterparty of at least the potential of patent by patent review of the set portfolio. And the second is the actually taking the position that it will require respective licensor to litigate over every patent in every country in respect of its whole portfolio and behaving accordingly. And we can see from paras 89 and 90 that what Apple means by its first category is how I foreshadowed it, basically asking for information to be persuaded as to the quality of the portfolio on offer. And that's exactly the substance of para 89 and expanded upon in 90. To make it clear, what's being postulated is scrutiny to address matters such as over-declaration, claims to stack share. And they say at the end of 90 that an implementer can't be expected to sign up to licence demands without that opportunity. And paragraph 91 suggests that this is all Apple was doing. And the impression being given through these paragraphs is that the parties were debating a portfolio licence. They're all on the same page. These are points that go to the value of that portfolio, and both sides were accepting that Apple requires that portfolio licence. And we know from the dichotomy that Apple set up in paragraph 88 that they're saying that's different to actually taking the position that it will require the prospective licensor to litigate over every patent in every country in respect of the portfolio. My lords, the judge's findings of primary fact are clearly as to Apple doing the second category. Rather optimistically, paragraph 92 goes on and says the judge didn't find Apple engaged in the second category, and they suggest he found to the contrary. Please look at paragraph 92, because it's striking. What they point to is the judge pointing out that Apple frequently does take licences without conducting an examination of each and every patent. He goes on to say it's a negotiating ploy. The point seems to be that if in due course you take a license to a portfolio without seeing through that patent by patent strategy, there can be no hold-up. And the argument is, if Apple does this, it can't be doing the second category identified in paragraph 88, actually taking the position that it will require the prospective licensor to litigate every patent in every country. Whereas of course an implementer can take that position and pursue it until they consider the SEP owner is sufficiently, use the judge's words, softened up, and then take a portfolio license. This finding is nowhere near a finding that Apple doesn't engage in the second category of conduct. Indeed, as I've shown you, the judge's finding clearly amount to a finding they did. And I might also add, the logical consequence of the argument, seemingly advanced here, is absurd. And I say that because if you do exactly the second category and do relent and enter into a portfolio license, the logical consequence of that submission is that there has never been holdout. So that is bad, and not only is is it logically unsupportable, it's actually to miss the entire point of this, why the conduct's engaged in at all. It is to soften them up so as they're in a state of preparedness to accept a much lower figure and then do a portfolio deal. So, my lords, paragraph 93, the suggestion that Apple's conduct differs is simply unsustainable. And can I make the same point, make sure it's really hammered home, by showing the attempt Apple made to have these findings changed? Because it's clear Apple understood the judgment did make the findings they now suggest were not made. You'll recall the judge referred to that in his footnote to paragraph 20. Can you take out supplemental bundle 3, please? You need tab 13. This is the black, green and blue document. It's the composite document that we submitted to the judge on the draft judgment, and the section I need is 4 whole pages, page 140 to 143 of the bundle. Fortunately, the paragraph numbers being referred to all remain the same in the judgment. Can we pick it up at the heading Apple's approach to global licensing? And we see paragraph 20 of the judgment is singled out. And for my Lord's note, we see at the top of page 141, paragraph 211.3 is also picked out. And the thrust of the point being advanced here is that these two paragraphs are factually wrong. If you look at paragraph 112, so that's specifically for paragraph 20 of the judgment, you see that's what they're saying, and you see also in paragraph 116 on page 141 says in substance the same thing about the extract from paragraph 211 of the judgment. And we see in the extract of paragraph 211 the sentences underlined that they're particularly concerned about. Apple threatening patent by patent, country by country litigation to soften up their negotiating counterparties, that's underlined, as is the sentence at the end with the judge finding that this is something Apple deploy in pretty much every case the judge has seen. They're quite plainly seeking to get the judge to change these important, and I might add very serious findings. And we see what they rely upon are extracts from the bits that we've already seen in both paragraphs 207 and 245. They're picked out at the bottom of page 140, and also extracts from the transcript that we see at page 141. And if we go over the page to page 142, we see paragraph 118, the substance of how they say the judgment should be changed. Well, also, I hope I'm not being unfair in characterising the correction put forward here is precisely what they now seek to argue the judgment already said. And for good measure, they point out that paragraph 407, which they set out, should be changed to. Now, we objected to this. Our text is in green. perhaps worth noting, we say in the opening part of that paragraph that it's simply seeking to re-argue a point, and that's not the nature of the exercise. My lords might want to note that because it's perhaps important to the broader point where we see Apple advancing against my clients that we should, after receiving the judgment, have had a go at reopening matters the judge has purported to decide. But we go on and refer to other materials before the judge, the details of which need detain you. You can see at para 127 on page 143, there's a further response from Apple that maintains what they were seeking to do, saying it was appropriate. But the judge changed none of it. He made the findings he made, that I've drawn attention to, serious findings, and we can see from these efforts to get it changed that Apple fully appreciated they amounted to serious findings of the second category they identified. And if the judge had applied the right standard, he would have held that to be holdout. And as I said, it was how they conducted themselves time and time again. My lords, that's the principal line of argument. The second argument advanced by Apple is a criticism of our Annex 3. And that's paragraph 96 to 101. And they're trying to suggest that it's highly selective, and they seek to build on that and suggest that this is an exercise in island hopping, in effect to change the judge's finding of fact. They say, for instance, in paragraph 97, it's a head-on challenge to the judge's finding of fact. They also attempt to explain why devaluing SEPs was a legitimate aim and so on. All of this is said in paragraph 101 to be an exercise in island hopping, hoping to challenge the judge's evaluation of the facts. In my submission, that misses completely my complaint. My complaint is one of principle. I don't want to challenge the judge's finding of primary fact at all. On the contrary, I rely upon them. And you see that it's in fact Apple that really hates them. Had the judge approached this issue properly, applying the right standard, appreciating that adopting the pattern by pattern approach, the conduct that was deprecated by this court in Unwide Planet, is not Fran, it is the blueprint for holdout. Had he done that properly, he would have held that Apple's policy that they adopted again and again and again was holdout. Moreover, very serious holdout at that. So, my lord, that is it on holdout, unless my lords have any further questions for me on it. Can I turn to grounds 2 and 4? And the first of those is the contention that the judge was wrong to reject the comparables approach. The second, ground 4, that he was wrong to adopt his own methodology. And they're linked by a point I mentioned already, that you can't realistically decide to reject one without considering it against the alternative. And the judge didn't do that, as I've already identified. Now, we've seen that the reason the judge rejected the comparables approach is his rejection of the process of unpacking applied to them by the experts. And we saw his 3 subjectivities that he said were insurmountable, an insurmountable difficulty. You remember that? It was para 314, the main judgment. In fact, they were first identified in 301. The first was the different rate. We saw that means it's the licence expressed as a lump sum or as one of the prices per unit. The second was cross-licensing, and the third was the issue of dealing with the past and future sales. So the judge rejected the parties and their experts' evidence and approach because of what he viewed was the insurmountable difficulty of dealing with these issues. Each, he said, was a subjectivity. And the judge, as we've seen, thought unpacking was both a process to move from a licence expressed as a lump sum to give a unit price. Typically, he was concerned with ad valorem. But he also thought that unpacking was moving in the opposite direction. We've seen that a lot. So taking an ad valorem price and seeking to translate, to use the judge's word, into a lump sum. And I've explained to my lords why that's wrong. Unpacking is simply what you do to a lump sum to provide the best view of a price per device sold. And can I just make some basic points about this? The first point is the point of this unpacking is to be able to take account of differences in units to be sold. That's the point, to give you a unit price. The point is that when you then, what's actually paid, whether you actually pay by accounting every quarter or you pack it up as a lump sum, but the point of it is to take account of differences in units sold. So the whole point of the exercise is to put yourself in a position where you are able to take account of differences in units anticipated to be sold. The next simple point I make is this: deciding not to go down a route where you don't do something, or sorry, deciding to go down a route where you do not take account of a difference in units anticipated to be sold, as between different agreements and as for the putative license being valued, is actually not removing the subjectivity from the picture at all. Let me explain why I say that. It is deciding to deal with that issue in a particular way. More specifically, it's to decide to deal with the issue, i.e. differences in units anticipated to be sold, as if the issue had no effect on price across all the licenses you're using and indeed the license that you're valuing. You are making a subjective decision as to how to deal with it. It may be a terrible decision, but the idea that it's removed from the picture as an issue to be addressed, or that the way you do it is not open to criticism as a subjectivity, is completely wrong in my submission. And in fact, my lords, I'll make the more general observation. That's true of any fact that one decides to take account of or not take account of. A decision not to take account of something is in fact a decision as to how you're treating it. And generally in these cases, depending upon the nature of the issue, you're either giving it zero value by doing that, or at least giving it equal value in all agreements. It is a subjective decision you're in fact making. As I say, it may be a terrible decision or a less terrible one, but the point, the principle I'm making here is that the judge appeared to think he was avoiding these issues at all, i.e. avoiding dealing with the subjectivities that he considered to be the insurmountable difficulty. If we consider the second one, the cross-license, this is an issue that is actually also related to units anticipated to be sold under the agreement, but also the value of the cross-license portfolio. If you decided not to take the cross-license into account at all, that's a positive decision to deal with it by attributing no value. Likewise, the third one, existence of past sales in addition to anticipated future sales. That is related both to the numbers of units, but also the discounts applied to their value in the past in real-life licenses. If one decided not to take the past sales into account, that is a positive decision, just as much as deciding to do so, or whatever particular way you decide to do it. And each of them is just as open to the criticism that it's a subjective. In fact, not taking them into account is the decision taken in the free release unpacking, because all the consideration is attributable to the future. But my point is, making some other decision, seemingly so as to exclude the factor, is actually a decision as to how to deal with it. And my lords will already have realised that despite the judge saying he was rejecting unpacking because of the insurmountable difficulties of these subjectivities, he did in fact make his own decisions as to how he was dealing with them. As I've already pointed out, by using a lump sum licence as flat fees, he was deciding that the variation in units anticipated to be sold under each agreement was to have no effect. They're all to be treated as the same across all the different Apple licenses and the Google licence. My lords would have realised that the judge did in fact make his own decision as to how to deal with subjectivities 2 and 3. We say, with the greatest respect to the judge, decisions bordering on the absurd, certainly much worse than the way the experts and the parties dealt with them. For example, subjectivity 2, the cross license. He didn't avoid having to deal with that. What he was actually saying early in the judgment was an insurmountable difficulty. He then had to deal with it. His own method was to have this idea of a netting off of a stack share, paying no regard to the huge disparities in units actually anticipated to be sold, but he had to deal with it. Whichever way he decided to address it, even if he decided no value at all, it's still a positive decision. Similarly, the third subjectivity, past sales, he still had to deal with it. He dealt with it in what we say is a very poor way, but the point here is that by looking at this as a subjectivity and then going down his own route, he did not avoid having to deal with it. He was actually making a decision as to how to deal with it by splitting it 50-50. My point here is not so much that it's an extremely poor thing to do, but he is dealing with this insurmountable subjectivity. And please note, my lords, at this point in the argument, the broad axe argument is of no use whatever. That is a point that might permit gaps in evidence to be filled in by less accurate assessments, which is a very long way from what the judge did anyway, as we'll come on to. But at this point in the argument, the point is the judge is saying he's rejecting the unpacking and indeed the considerable degree of common ground as to the comparables approach, because it actually involved dealing with the issues. So broad axe is just another way of saying I want to deal with the issue in whatever way. So the broad axe argument does not even begin to meet this part of the case. And can I point out that the point I've just been making, they're in fact redolent of a point that my Lord Justice Birss made in the Unwired Planet case at first instance. And the reference for this is Authorities Bundle 4. And
Do I get to charge you a royalty, Mr. Speck?
Pardon?
Do I get to charge you a royalty every time?
How are we going to calculate it?
True verse rate.
I've now completely lost where I was. Tab 1, I think pages 76 and 77. And what I have in mind is actually a passage that follows on from the marked passage. So it's paragraphs 269 and 270, which we did refer to in our skeleton at 33 and 34. So sorry, it should have been marked as well. And just put my lords in context. What my lord is addressing here is whether a top-down approach is better than a comparables approach, or whether it really is best used only as a cross-check. And the real issue my lord identifies is that if using it as an actual method in place of the comparables case, one has to calculate your top number, you call it T. And the point I wanted to draw out was an observation my lord made at para 270, so at the foot of page 77 over to the top of the next page, and it's this. Having expressed concern about using statements made by parties in the industry as to T, my lord identified that comparable licences are concrete data points, albeit their interpretation could be uncertain and so on. You go on and explain you could use comparable licences to try to derive a figure for the total royalty burden. And then this, the absolutely key observation. But to achieve that requires one to have done all the same work which is needed to apply the comparables directly anyway. So back calculating T won't add anything. Now, of course, my lord is making this observation in the context of an issue as to using the comparables to calculate T for a top-down assessment. But my submission is that this is in fact a broader point applicable to our situation too. If you're using the comparables, you need to address the issues that need to be addressed in the conventional comparables exercise. You don't avoid it by considering you're ignoring matters that arise, because as I've said, doing that is making a decision on how they're dealt with. So if you decide to go to the comparables, then all of the issues that normally arise, you have to deal with. And so the judge's reason for rejecting comparables, thinking that he was avoiding this insurmountable difficulty of the subjectivity, is just misconceived in my submission. And we make the point at the end of paragraph 89, this is page 76 of the bundle in our skeleton, that what the judge should have done is to make findings as to which of the experts' views he preferred as to how the matters he identified were addressed. And I've already flagged that there was not a great deal of dispute between them on their unpacking for almost all of the licences. As I've explained, it was more significant for Ericsson, and of course he actually only needs to resolve those differences on the licences that the court might consider the best comparable or comparables.
Just on that point, can I ask a question? I think you have made this clear, but just so as I'm not in any doubt about it. Am I right in understanding that just as in Interdigital and Novo, in this case, neither side's expert opined upon the question of which licence or licences was most comparable. Rather, they directed their focus to the question of analysis of the financial information which one could get out of the proposed comparables on each side.
I think that's certainly true as the broad brush, and certainly from my knowledge of Mr. Bizant's approach, because he was the expert in digital, that's what he did. The reason I might hesitate a little bit from giving my lord an unqualified yes to that is that, do you remember when my learned friend stood up yesterday because I mentioned the number of comparables they'd identified in their case, in the pleading? I think there was, if I recall, there was something in Miss Guttridge's evidence identifying those as ones to look at particularly. I think, but standing here, I can't tell you.
So this is, the proposition is that Miss Guttridge opined to the effect that the Apple comparables, being those that Apple relied upon, were comparable to the notional licence, and the Optis licences were not comparable.
Quite possibly implicitly, but the point I was answering my lord on is that she specifically identified, I don't want to say the number again because I upset Mr. Nicholson, but you remember the number in the pleading as to how many were particularly focused on. We had the table of whatever it was, the 14.
But focusing on whatever number of licenses it is, doesn't involve expressing any opinion as to comparability, let alone giving reasons for that.
But that's what I don't want to say definitely not, nothing like that at all. I don't recall it being a major part, but I just stood here now, my lord. I do not want to say definitely not when
no, caution is appropriate. But if evidence was given as to the opinion of the experts as to pure comparability, as opposed to what financial information you could derive from the licenses in question, I would be interested to know that, and even more interested to know whether the judge expressed a preference for one view over the other. I mean, my impression at the moment is that he didn't do that because no such opinions were aired.
Well, I'm pretty sure he didn't do it, and I'm pretty sure that if there was any opinion, it would only have been a very light touch. But I really don't want to tell my lord definitely not, standing here on my feet. But we will look, and we'll make sure that I can give my lord a fuller answer to that question. But I think I was on the point saying that, you know, there was that particular dispute on Ericsson and the particular peculiarity about what Miss Guttridge did in terms of our unpacking. So it was on the point that my lord obviously knows that they were dealing with, but on the whole, the dispute between them wasn't that great, and I showed you yesterday that actually Apple relied upon that and said that it doesn't really matter too much what you're doing in terms of taking figures from one or the other. And in fact, you can tell when you look at I'm not going to turn it up now, but if you look at the numbers when they're scaled to the Optis license in that appendix that we were looking at before lunch, the numbers are pretty consistent, save for the Ericsson one that I drew attention to. Now, on the dispute between the parties on those matters, my Lords know also that there was this dispute for Google that I've highlighted already. But you know that what that turned on was the number of units. And we know that the range in which that dispute straddles is either the way in which Mr. Bazant unpacked it, which Miss Guttridge was happy to take to use in her evidence, or it might be half of that, or somewhere in the middle, because of the dispute about the number of units that may properly have been anticipated. But apart from that, on Google doesn't need scaling to the Optis portfolio. So the argument about what's the best measure of the license, the portfolio strength, it doesn't need it. It would, of course, need reducing by taking out the fraction of the ex-Ericsson patents, but that's simple arithmetic. What you don't need is a measure of the size of the portfolio when the license is to the strength of the portfolio, when the license is to the portfolio. So there's no need for the dispute as to the better methods of measuring portfolio strength to be resolved at all for use of that license. And that's part of the reason why comparable licenses on the portfolio in question are so key. So the debate about which method deals best with the over-declaration problem and the like is simply not part of the picture. And of course, Google is a very substantial company. The judge considered they would have negotiated properly. In a nutshell, my lords, what's not to like? Once the misconceived point rejecting unpacking that led the judge to reject the comparables has been appreciated, what's not to like about Google? Now, of course, my friends say, look at the number you get from Google. That suggests an overall price for the whole stack is too high. And this is where they deploy the inography scaling factor. It's not necessary to have any measure to derive the actual price. It's only where you want to do this kind of cross-check calculation that the measure for the portfolio strength comes in at all. But the issue for my lords then is basically this. Once I've shown an error of principle, as I submit I have, such that the comparables approach was wrongly rejected, you have to exercise that judgment again yourselves. And the issue for you is this: the fact that I cannot and do not challenge the as an error of principle needed for the foundation of my appeal, the judge's overall assessment to use inography in the context of his own method. We say doesn't mean a cross-check exercise using inography should, in my Lord's de novo evaluation, cause my Lords to reject what appears to be a most excellent comparable. We can err on the side of the number of units they said would be contemplated, not what Mr. Blasius said or some other assessment, but you know the range in which the dispute is being had for that. It doesn't matter for my point. The real issue for my Lords is once the error of principle is established and a de novo assessment arises for my Lords, assuming that you're not minded to send things back to a first instance judge, the de novo assessment falls to my Lords, and then the issue is whether a cross-check using inography as opposed to PA is something that will cause my Lords to reject as a reliable indicator of price an agreement actually on the Optis portfolio agreed by this major player, given the judge's findings of primary fact as to its approach to the deal. And a further reason we give as to why Apple's inography cross-check shouldn't deter my Lords is this. When using a measure of portfolio strength in this way as a cross-check, the number that you get is in a very real sense a check for both the measure of the portfolio and the price one has from the comparable. It is not simply a check on one of them, assuming the other is right. And the reality is, my friends want my lords to think it is. That is the nub of it. There are recognised potential uncertainties and errors in the measures being used for portfolio strength, as we point out in paragraphs 91b of our skeleton. Moreover, the judge himself had recognised that small portfolios were particularly sensitive to such uncertainties, as we record in the passage at the top of page 77. And what it is, in short, is where the actual size of the possible error is comparable to, or perhaps even larger than the actual number itself, which is what you get to when you're looking at small stacks of shares. When one then scales to 100% to get an indication of the size of the stack, you can be substantially out. So if you've got an error, if you've got a stack size that's 0.5% and an error of 0.5% or 1%, when you then scale that up, you'll double out or 3 times out, because the size of the error is comparable to the thing itself. And that's what causes the problem. And the judge recognised that. And I'll come on to explain what the judge did to test for that. I've already alluded to what it actually showed and why it got deleted. But before I do that, what I do want my lords to just pause and pay attention to is that Google is obviously very substantial and well resourced and would have negotiated properly, as the judge found. It did in fact agree the license, and the DPU that is implied from it is in the region that one can see in the appendices to our letter. Any cross-check using a particular measure of portfolio strength that suggests an excessive overall stack price does not per se indicate there's something wrong with the price of the comparable. It could indicate either the measure of the portfolio strength is in fact inaccurate, or it could indicate that Google did a madly inexpensive deal. Those are the two things in play, and given the judge's finding of primary fact as to Google negotiating properly, the latter really is very unlikely. And the crux of the matter really is this, my lords. When exercising the assessment yourselves, as I've shown an error of principle, do you think the number one gets from using enography for this cross-check means you should reject the otherwise obviously best comparable?
So can I just ask you about that? So you'd accept that on the face of it, if you use the enography data, you get an implausibly large number?
I wouldn't say implausibly. We'll go to the number in due course. Okay. But it's a number that's nothing like what the judge thought. It's the number that my Lord Justice Birss was pointing to yesterday. It is a number which is it is higher than most people as a gut reaction would think is reasonable, but it is nothing like, I wouldn't say implausible, but and I'll show you how the error in the stack size easily accounts for that. Easily.
And when you say the error in the stack size, you mean as compared with PA Consulting?
Yes, and the one that the judge was contemplating, and in fact PA is slap bang in what the judge was contemplating.
Yes.
Exactly that. Exactly that.
Okay.
And frankly, to be absolutely clear, my lord, the stack size as measured on enography is just a bit over 0.5%. On PA, it's about 1.5. The judge did a test looking at what happens if it's 1, what happens if it's 2, and the factor of 0.5 to 1.5 is a factor of 3. And if you look at the cross-check number the judge used, and you use the factor of 3, you are easily in the range that's fine. That's the guts of it.
And then just thinking about it a bit more, you say, well, when you've got such a small share and you scale up, things can go terribly wrong.
Yeah.
Should one worry in terms of doing a more, as you would say, conventional exercise of arriving at some kind of price per unit, that you're still only dealing with a very small share? What one deal on a very small share?
But it's the deal, the best comparable on the portfolio in issue. That doesn't affect the issue about the error on what the share is. It was on that share. It is the best deal, and my lord may recall that one of the first things I said to you yesterday morning is, actually in both the previous cases, it turned out that there was a single comparable which was the best thing to look at.
Yeah. And as you say, the single licence in question was in each case a licence of the portfolio in issue. Certainly in individual it was. It was a bit more complicated in our
It was part of it.
Yeah.
In my lord's case, but yes, it was as close.
Digital, it was the exact.
It was
one.
in digital.
And it was in the end what was relied on was just one licence.
One licence, and my lord in Unwired Planet relied upon a licence which was it was one licence, and it was I can't even remember how much I can say about that now. So I don't want somebody in Mr. Nicholson's position jumping up, but it was akin to being for the portfolio, but as close as you could get on the material.
In case you think so, Mr. Speck, I've got no recollection of that. So the fact that I'm being quiet doesn't mean I agree with you. It doesn't mean I disagree with you, but I'm just not affirming or denying.
Now, but in effect, my friends are asking you to say that you should conclude that Google did do a shockingly overvalued deal, despite the judge's findings, which ought to lead you to conclude that this is unlikely in the extreme. And in fact, I can go further than that, because the judge was completely alive to this, as I've foreshadowed, and he actually included a test on this sensitivity with dealing with the small stack share portfolios. He referred to the sensitivity of small portfolios in the judgment at 468 and 469. But he actually did and looked into the detail in his draft judgment. He carried out what you might call a check on the cross-check with these higher stack shares. And the point in his draft judgments is to illustrate that the Optis comparables gave unrealistically high numbers, even with the higher stack shares that perhaps it might have truly been. And the trouble, as I've already alluded to, my lords, is that this part of the draft judgment was a complete muddle. In fact, I'm being generous with that description. It was worse than that. And when corrected, it actually supported the opposite conclusion, so he simply deleted it. And it's part of one of the grounds that I rely on the grounds for the draft judgment. But I need to show you what happened. It's the point that I promised I'd come back to and show you. So we need both the judgment and the draft together, please. And I'll try and do this in a way that is a bit less confusing than it was when I was trying to do this yesterday. So it's the judgment in Core 1 and the draft in Core 2. And it's Core 2, Tab 2 for the draft. The main judgment we need page 474 of Core 1. And it's page 313 in Core 2. And what I want to start with is a stark contrast and some conclusions. So that's the heading on page 313 or page 474 respectively. And paragraph 467 is the same point in both judgments. But look, please, what the judge thought when he was writing the judgment as to the ad valorem rates was simply a small fraction of the stack in subparagraph little 1 on page 313 of core 2 in the draft. This is just for a small fraction of the stack. He's saying he gives both the simple and free release, and look what he thought the Apple comparables gave for about twice the fraction.
Those, sorry, what are those percentages? Those ad valorem royalties.
Yeah, yeah, absolutely.
So just to be honest, I mean, in other words, it's a number which is bigger than the average selling, well, bigger than the price.
Yeah, it's
So had the judge been right about that, that would have been ridiculous.
yeah. And that's not even for the whole lot.
No.
Yeah. For the relevant share,
Yeah, yeah.
you'd be paying more than the price of.
He gives both simple. I mean, it's, when I say it was catastrophically wrong, it was. That's what the judge thought when his draft was written.
Yes, this is a finding that says if I take the Apple comparables in the way I'm doing it, then the royalty rate the implementer would be paying would be some fold multiple of the price of the unit.
And you can see what he says from the Optis comparables.
Yeah, they're the Optis ones. And
then the Apple ones are later on.
Yeah.
And that's what, he wasn't just a bit out. This, as I keep saying, is just a catastrophic miscalculation. That's what he thought when the whole of this draft judgment was written. That's what he thought the cases that I advanced. Look what the judge thought our overall stack ad valorem rate would be in paragraph little 2. I mean, it
would be on the high side.
But look at it.
As the judge says, economically impossible.
Yes, perhaps understated. But that's what the judge thought. I'm not sure why. Well, so the judge says in sub-para 3, the unsustainable nature of my client's rates is massive. I'm not sure why we've marked up this bit in subparagraph 2 as confidential, because it doesn't bear any relationship to any actual commercial information. But you can just see, this is what the judge thought when he wrote this. And I've tried to get on top of just how many errors underlay this, and it was subject to extensive corrections in the blue and green joint document, and I think tables that were sent in that you haven't been troubled with. Suffice to say, as I understand it, there were several and they were large. This isn't even wrong by 1 or 2 orders of magnitude. It is just unreal. Can I show you what else was in this run of the draft judgment? Can you go to page 315? This is the paragraph dealing with Google. Similar to text that's in paragraph 473, little b, in the main judgment at page 476 of core 1. But look at the draft judgment version. Look at what the judge says about the implied ad valorem rate for a tiny fraction of the stack identified there. Which he says is commercially ludicrous. Indeed. My lords can eyeball that and think what that would imply for 100% of the stack. But these numbers in the draft judgment are just nowhere near the reality of the case being advanced on the materials before the judge, not even close. Look, please, what the judge says at subparagraph 4 on page 316 of core 2. This is what he says the Apple comparables imply for an overall stack ad valorem price. Look at those two numbers that he gives in the fourth
Sorry,
line
I've
of the
got
paragraph.
lost. Where are you?
Yeah, sorry.
Oh, you're in the draft.
I'm in the draft.
Yes, sorry.
I'm on page 316,
Yes.
and I'm in subparagraph 4.
Yes. No, I'm with you. I was looking at the final version where there isn't a 4. The draft does have a
Draft. And I'm inviting my lords to look at those two numbers in line 4. They're highlighted.
Subparagraph 4.
Subparagraph 4, yeah, and it's line 4 of that
Oh, I
subparagraph.
see.
Can you see those two numbers, which he says neither of them is out of court? Please look at the higher of the two and perhaps round it to the nearest percent to remember it. Neither of them are out of court, meaning that both of those would be reasonable. The judge's view, that would pass the cross-check sense. What the judge did in the draft is recognise the sensitivities in this kind of analysis. Rework Mr. Bazant's figures assuming a 1% or 2% of the stack being held by Optis. And he explains that's what he's doing in the text just above the table starting at the page, at the foot of page 316. See where he says, accordingly I've reworked. So that's what he's done, and the substance of the table is over the page. And this is a table we intended to show that even on these assumptions, in the case of the stack share, 1 or 2%, the rates are economically unsustainable. And that's indeed what we see the judge say about them in 471. And as I think I've already told my lords, a stack share in this region between 1 and 2% is precisely what the approach we had advocated for, which took over declaration into account using PA, actually showed. So although the judge ultimately preferred inography for his method, he certainly was recognising the possibility of it really being in this region, and the point of what he was doing was to do this exercise to show the rates were in any event economically unsustainable. We look at the table though, the first thing that strikes you is the rates here are nowhere near silly figures. The judge called them ludicrous on pages 313 or 315, but it's very hard to understand how he's had these numbers also said to pertain to the Optis comparables so close to the others in the draft judgment. You wonder whether perhaps the cross-check section started on 316 was separate in time. I can't help, my lords, but they're supposedly relating to the same agreements. But can I also draw attention to the fact that the judge failed to do the obvious divide by 2 operation on the numbers given on the basis of 1% to give the 2% numbers? If you double the stack share, obviously the effect of the overall stack price is halving. He's just forgotten to do it. The 2 columns are the same in the 1% realm as they are for 2%. Every single one of them, apart from one where there's a typo. It's all pretty extraordinary and all obviously wrong. But look at the number for Google. Look at that. Look at the simple 2% stack share number. So that number ending in a digit 2. Look at it. And my lords, please do the obvious correction by dividing by 2. Gives you a percentage which happens to be one that the judge has said were not out of court. You've done it right.
I see. So those numbers aren't percentages, those numbers are fractions.
Yeah.
I see. So if it was 0.76, it's actually 76%. If it was, it's not. We're just making up a number, not pointing to any particular one.
I think so, yeah. That's what, yeah. That's the implied overall stack. So it's actually a number that he's already said is okay. And when it came to it, the sensitivities that the judge recognised, and the exercise he did show that the effect of the sensitivities actually show that Google licence is not at all unreasonable. In my submission, as one would expect for a licence properly negotiated by a party like Google. So in the main judgment, when all these errors are pointed out, it's simply deleted and it's all forgotten. If we go back to the main judgment...
I'm so sorry, Mr. Speck. I'm afraid I am now thoroughly confused.
Right.
The number that you wanted us to round up to the nearest whole number of numbers was the number in the fourth row of little Roman 4
Yeah.
in 467. That's not a stack share.
Hang on, 46. No, it was the fourth row on 316 in the draft.
316.
Yeah, so I'm in core 2. It's only in
Yes, that's right. Roman
That's for
4.
the share stated in the third line.
right.
Just asking.
So it says, by contrast, unpacked Apple comparables give something of a more realistic indication. That's not blue. Then it says something in blue.
Yeah.
And the number you wanted us to round up was the last of those numbers.
Yes, because it says that. Well, it's not the share in the first sentence there. It says what he's done in the second
And then it
sentence.
says uprated to 100%.
Yeah.
Something, something, something.
Yeah.
And it's the last number there.
Yeah, it's the last.
You wanted to round that up.
Yeah.
Because I understand that number there. That number isn't a stack share.
No.
That number is a royalty.
Exactly.
Right?
Yes.
So those numbers in that table, I thought I asked you and I thought you said yes, but I think you probably didn't understand what my question was.
Right.
Those numbers in the table on page 317
Yeah.
are royalties.
Ad valorem rates.
Yes.
Just what?
Not stack shares.
No. The stack share is the assumed stack share in the top of the column. So they're royalties again. I'm
Sure it all is, Mr. Speck, because you live with this case.
Yeah. I don't think I'm asking my lord to compare apples with oranges.
No, I understand now. The point is that number there that's a point something is an ad valorem royalty rate.
Exactly.
Not a
And if
stack
you
share.
do the correction,
Yes.
it's the
I
same.
get it.
Yeah, and you have to do the correction because, as you pointed out, when you come to the 2%, the judge failed to divide by 2.
Exactly.
That's why the number is the same as for 1%.
Exactly. If you do it properly, you've got an ad valorem for the stack, which he'd already told you on the previous page is okay.
And this is an implied ad valorem rate for the whole stack.
Yeah. So in the main judgment, when all these errors are pointed out, the exercise doesn't do what the judge wanted it to do. It in fact proves exactly the opposite, so it's all deleted. And if we go back to the main judgment, we see the paragraph that concerning Google that we were looking at before. So I'm in page 476 of core 1, sub B, at the bottom hole. This is, my lord may recall, you asked me yesterday, is that number, do I say it's reasonable or not? 476.
Mm-hmm.
The one highlighted in blue in the bottom line of subparagraph B. And I said it's not, but that's because he's gone back to treating the stack share as set in stone as 0.6. The minute, and you could do the same exercise here, the minute you realise that the stack share actually could be up in the region that we've just been testing for, you can do the same effect by saying, look, that's a factor of 3, which means I've got to divide that by 3, and you get another reasonable number. And just to be absolutely clear where that number came from, that's in table 10 on page 473. And that's the table that sets out what the rates for the stack on different licenses are implied for, and it's the entry for Google in the simple column. So if you go about the top hole punch, it's the left hand of the blue one, with the blue highlighted. That's where it comes from.
So he is adopting a Mr. Besant rate.
Yes, but more to the point, he's saying that that's what it gives you if you had set in stone that you knew for sure the stack measure was 0.6.
0.61. Just so that we can all be clear
Yeah,
where
exactly.
the number comes from.
But he recognised that the debate before him was between about 1.5 and that, and he did the test to try to show that it didn't matter, that it was unreasonable. But actually, when you do that, you can see that it's perfectly reasonable. So what happened is it was deleted, and the judge pressed on and made the same point anyway in that paragraph that we were just looking at. On page 476, subpara B, very slightly watered down, but only marginally.
And just sort of possibly picking up what my lord was asking, in valuation contexts I've come across elsewhere, say when you're doing a share valuation or a property valuation, a rent review, something of that kind, the experts don't just analyse the potential comparables, they say we think this one is the best, and they come up with a suggested figure. But that didn't happen here.
They certainly came up with, certainly Miss Guttridge came up with a suggested figure because of doing the SSPPU exercises, although there were several of them. In terms of the comparables, I think we are back to the question that my lord asked
Yes.
me, and I don't want to.
What I just sort of would like to be clear about, so Mr. Besant has come up with the figure which the judge is then using.
Oh, that's just an unpacking from Google, though. That's not
Quite, but on this hypothesis, I think you're saying, well, it's only Google that matters, really. So was he then saying, well, that must be the answer?
He certainly was saying that's the information that you get from Google. My recollection, and again, I don't want to say without checking that there was nothing at all to say some of them might be a bit more helpful than others. But certainly Mr. Besant generally, because I know from other cases, his approach is to tell you what the whole landscape is.
Yes.
And it's for the judge to decide which is the most comparable. He may point out things which would cause worry and that you need to concern yourself with. But I mean, it's a massive amount of evidence, and I don't want to say something as categorically as
No, well, you're right to be cautious, but I mean, looking at the principle, what happened in Interdigital and Nova, as you recall, was that Mr. Justice Mellor was critical of both sides' experts for not expressing. Sorry, we seem to have some extraneous noise. If that's from anybody's device, could it be turned
I think
off?
it's outside my
Okay.
lord.
Mr. Justice Mellor was critical of both sides' experts for not expressing a view on comparability and simply for doing the financial analysis. Now, as things turned out, it didn't matter because the judge was able to identify a single comparable, and in the end that was accepted on appeal. And then the question was the financial analysis. But if you wind back and ask oneself, was the criticism justified in the first place? I mean, we didn't have to go there in the Court of Appeal because it didn't matter.
No, indeed.
But it would be perfectly reasonable to say, well, the criticism was never justified in the first place because it wasn't within their province. Yes, they were experts in this field, but what that meant was they were experts in the financial analysis. They were not experts as to comparability of patent licenses from the perspective which we are concerned, because that, at the end of the day, is a question of law.
But certainly an assessment for the court rather than an expert saying this is better because it involves an appreciation of all sorts of factual circumstances. So I agree with what my lord's saying. And
At any rate, at minimum, it has to be supported by reasons such as we're talking about the portfolio in question or we're not.
sure.
and factors of that kind.
And I think perhaps that's one of the things that was going through my mind. I think it's quite possible, perhaps likely, that Mr. Bazant might have said that would be his starting point and prefer to look at the portfolio in question. So one might say that is an indication of to which ones to look at.
Yeah.
So I don't want to say there was nothing at all. Certainly not without actually reading the whole lot with that question in mind. But certainly Mr. Bazant's approach, from my recollection, both in this case and previous cases, is tell the court everything. They make the decision.
This is a bit of a tangent, but I have to say, I don't quite see why the approach in this field should be different from the approach taken in any other field. And if you take, say, share valuation, an expert will analyse other share sales, try to work out from those what an appropriate multiplier might be, what the figure should be for EBITDA, and then we'll come up with a figure. And I really don't know why it should be different here. And in terms of insurmountable difficulties or whatever the judge talked about, I mean, there are absolutely equivalent problems in other areas of valuation,
Sure.
where experts arrive at views.
It might be, because certainly some of what goes on here involves a decision as to, for instance, what source do you take for projected sales?
But that's the same sort of thing that experts
Maybe,
do all the time.
or maybe the experts in shares know how to do that, but it's. I don't know.
No. I mean, anyway, coming back to the Google figure, Mr. Bazant having come up with his number, which might or might not, taken without further assessment, look on the high side, he didn't work through and say, well, I think the appropriate figure should be such and such.
No. But what's happening here is what the judge is doing is taking that and saying, well, that implies in fact, I think that figure, the prorated to 1%, has actually been done by the judge.
I see, yes.
So that, but it's based upon Mr. Bazant's unpacking.
Yes.
That's where he's got it from. So he's not actually taken the figure
So
straight
it's
out.
implicit in Mr. Bazant's working, but
Yeah.
not followed through.
Yeah, absolutely. But the key point that I wanted to make to my lords, perhaps I've already made it, I can't remember, subparagraph B on page 476, is that the way the judge now has to put it is to just give the number on the basis of the 0.6% stack share without any allowance as to what the error might mean. And you can tell by, as I say, if you take the midpoint between the 1% and 2% and say, well, what if it was 1.5 instead of just over a half, you can tell that you're going to be dividing that by 3. And so that would be expressly okay. And the judge was right to think this sensitivity was important and mattered. And, my lords, I might add that on this is all based upon Mr. Bazant's unpacking using the sale figures from Mr. Blasius. The ad valorem rate would be decreased again if one proceeded to use the alternative source of figures that's been put forward by my friend. There's possibly a further factor of 2 reduction in there. And what that means is the upshot is the stack share needn't even vary in the kind of range the judge was contemplating to be within a reasonable range.
I mean, the trouble with that is that suggests that your rounded up figure, which you say the judge thought could be right, could just as well be half that.
That, you're right about that, which means that the unit price that you took would be half that. But my point is this. The dispute between the parties as to what Google gave you was, I mean, not insignificant, but not the kind of thing that I mean, it was a factor of 2. We know that the price is either what Mr. Bazant got out of it, or half of that, or somewhere in between. And the point I'm making is that all of these calculations where I say it's actually reasonable is at the top end.
And I see all this, but if you were then saying to us, as I think you sort of were, well, really, you have to judge it all by Google. Looking no further than Google, you get a range of possible figures.
Sure, but that's still the best thing that you've got. What it means is you might have to take a view as to what the best way of unpacking it is.
I mean, you might then hope in other circumstances at least to find a cross-check somewhere else.
To be perfectly frank, my lord, in terms of what it gives compared to what the judge gave us, the lower
You'd
one...
be happy with anything.
The lower one is still... I'm not making the submission that I'm happy with anything, but you understand the point. The point is that we're nowhere near what the judge did, and the fact that there may be that dispute between the unpacking using the Blasius projections or the IDC projections means that it's somewhere between there. And it's not an answer to say, well, let's forget it and go somewhere completely different.
On the contrary, it's straightforward to make decisions to which sales figures you're going to use, and it is even possible to split the difference.
Indeed, indeed. And when you're carrying out the assessment of fresh yourselves, this kind of argument is subject to the kind of uncertainties that the judge was well aware of and sought to address, but it was just deleted. I would suggest to my lords a much bigger problem would be for you to accept the conclusion urged on you by Apple that Apple should pay much less than Google per unit because Google must have negotiated a madly expensive deal. Because that is the essence of what they're saying, and given the judge's findings of primary fact as to it having the resources and motivation and wherewithal to negotiate properly, my submission to my lords is that is untenable. Now, my lords, we obviously have a further point on this topic, which is firmly in our ground four, which is a further point as to why rejecting the comparables approach and adopting his own methodology was an error, and that's the procedural point. The judge was quite wrong, we submit, to formulate an entirely new approach in his judgment, rejecting all the expert evidence and approach, much of which I've pointed out was common ground, at least the fundamental premises and the actual scope of the dispute between them was not that great. My clients, and indeed Apple also, had no opportunity to deal with it through evidence or submission. Of course, we know that we did have that question in one of the rows in that large spreadsheet asking about implied lump sums, which, looking back now, one can think perhaps the judge was already thinking about this. And one of the questions the judge asked us to cover in our closing was whether we agreed or disagreed that royalties should not be assessed on a lump sum basis. And we both said that it shouldn't. Can I show you that? Apple's supplementary, Apple's is at supplementary 1, tab 6, page 149. And it's paras 654 to 655. In particular, you see that they're saying that a lump sum is a mechanism for structuring payment. It's basically what we saw them say after the judgment. Optis also said no. That's actually in Sup 4, tab 4, page 68. And it's point 4 in the middle of the page, and we're agreeing to what we've set out above, that royalties should not be assessed on a lump sum basis. So page 68 of, maybe I'm going too quickly, tab 4 of supplementary, SAP 4. So you see, blue is the question that we've been asked to address, and we're agreeing that royalties shouldn't be assessed on a lump sum basis. We both agreed, but then the judge did what he did, and we were just presented with all the detail we've been through. Some of it was just, as I keep saying, catastrophically wrong on the sums. But we had no opportunity to address the guts of the approach at all in expert evidence or submission. And what is the answer that Apple put for both of these points? We say that they're particularly weak. First in its skeleton, this is paragraph 105, it seeks to rely upon broad acts. And they rely upon the DAF trucks case. Can we look at that? Because it's nowhere near this case. You need authorities bundle 3. Tab 7. I know my Lord Justice Newey knows this well. It's a case about what I understand is price collusion or fixing. And the particular issue they were concerned with is how to assess the increase in price caused by that collusion. And experts on either side had different approaches to the modelling. My friends rely upon paragraph 145, which is on page 361. In fact, it's paragraphs 145 to 148 that are marked. Now, my reading of this, 145 introduces what's referred to as a principle of broad acts in the context of difficulties in quantifying loss. Para 146 refers to imprecision in the experts' regression models in this case, and that the CAT declined to score the experts issue by issue in order to arrive at a figure for the overcharge. And they said that would have been spurious accuracy. And we see in that paragraph what instead happened was CAT indicated on the two key variables it identified which party had the better argument. And the Chancellor said this is the middle of 146, this was entirely warranted. And we see from the second half of para 146 that the CAT did a careful analysis on those key points or variables. And looking at 147, having taken account of its assessment of the evidence, the conclusion, and this is said to be the broad acts, that a figure of 5% was appropriate as the overcharge. And it wasn't simply splitting the difference approach, although in fact it was about half of what had been claimed, but it clearly wasn't arrived at by just splitting the difference. And the Chancellor goes on in paragraph 148 and says this is precisely the sort of case, sort of situation where wielding a broad axe is appropriate. And he went on to say it can't be right for DAF to fail to disclose potentially inculpatory material which might shed light upon the reality of the participation in the cartel and its impact on prices, and for its expert to then advance a case that there was no overcharge. Reading over the page, the end of 148 says the court's entitled to ask rhetorically how an appellant can complain when the CAT plugs the gaps in the evidence by wielding a broad axe. So the upshot here was that having engaged in a cartel, DAF had failed to disclose material, and then it was arguing that the effect of it participating in the cartel was in fact no overcharge. So it's a kind of argument that it was a particularly pointless or ineffectual cartel, if you like, and that there were gaps in the evidence caused by the appellant itself. And what is clear, my lords, is this is not a case of the CAT departing from the scope of the dispute before it to engage on a significantly different exercise. What it did was, faced with the gaps in the evidence, look at the experts' respective modelling, and instead of making a decision on every single point between them, it analysed the key ones and arrived at the figure of 5%. No doubt scoring every single point would have required someone to have then constructed a different model adopting the different combinations or permutations that would have ended up spitting out a different but spuriously precise number. And so approaching the scope of the dispute between the experts in this way is perfectly sensible, but it's nothing like what happened here. And my lord, you get a further feel for the nature of what's contemplated by broad acts and its use being a way to plug gaps by looking at the judgment of Lord Justice Green. That starts on page 365. And we see, this is paragraph 166, His Lordship is concurring with the Chancellor, and the whole point of the judgment was to deal with this broad acts issue. And if we could turn on to 172 on page 369, this is the passage addressing the expert evidence, paragraph 172. Line 2, it said that it was huge and excessive, and we see 6 or so lines down, DAF conducted the trial at the level of economic theory, not reality. And we see the mention of the fact that it would or might have been different if DAF had tendered evidence as to the modus operandi of the cartel. So there's a pretty big gap in the material or evidence, my lords. Next, halfway through 172, we see that the regression analysis risk-generating results, which were broad brush and left gaps, that the CAT would have to plug. And there's also a reference to the limitations on regression analyses anyway. And the end of the paragraph sets out that in this case that was exacerbated by 4 factors identified towards the end of the passage above. So just above the quote, you see 4 things that are identified. That's the reliability of assumptions underpinning the modelling, the duration of the cartel, the number of significant regulatory challenges for vehicles, and the global financial crisis. And the CAT's conclusion is set out. There was a vast amount of work, but numerous and serious gaps and unresolved issues. Specifically, they say it's not possible to specify an ideal regression equation based upon the various work that could be relied upon. And that's what I meant earlier when I said they were refusing to make a whole series of individual decisions and then ask somebody else to come up with the other model to spit out the answer. It just wasn't possible. There were too many imperfections in the evidence to allow that approach. So if we go over the page to paragraph 173, we see that this led to a position at trial where there was a significant spread between the overcharge calculated by competing experts, and resolving that sort of scoring would have been spurious. So this case, the DAF case, was precisely the kind of situation the broad acts is designed for. But as we've seen, what that broad acts approach involved was to identify the key issues between the rival models analyses and assess who had the better of it to assess the overall number. That is a way to resolve the dispute within the framework presented by the parties and the experts, particularly in a case where there were big gaps. But that is not anything like throwing out large parts of what was agreed or common to the experts' approaches, and in substance to create even more gaps, which is what the judge did here. Our case really is nothing like what's being described here, and so it doesn't help, my friends, to rely upon DAF and the broad acts proposition in my submission. I think that's all I wanted to say on that. Another argument put forward by my friends in their skeleton is they seek to argue it was our fault for not providing the judge what he asked for. This is their skeleton, paragraph 106. Now, we've covered how we approach dealing with the judge's queries already, and the criticism of our approach is misconceived, as I've already explained. But even if there was anything in it, that's not an answer to the procedural point that being met with a new method of assessment in the judgment is procedurally unfair. What I think they're trying to do is to say that somehow we should have anticipated what the judge was going to do and told him it was wrong before he did it. That seems to be what they're trying to get at paragraph 106. They go on over the page in paragraph 107 to make a point that's equally poor in my submission. The contention seems to be that when we were provided with the draft, it was contemplated this kind of issue should have been raised because the parties' accountants were permitted access. Now, it's fair to say, I think, that Apple have backed off that somewhat in the note they filed last week. I have in mind paragraph 9 of it, where they now suggest that...
Sorry, when you say the note they filed last week,
Yes.
what are you referring to there?
A note they filed last week. Your Lordship, not...
Sup 4, tab 29. That's 5. Sup 5.
It's on some of the procedural issues. I hadn't appreciated that your Lordships didn't know about it.
This is a document headed Short Note in Response to Loss 42.
Yeah. What happened, my Lord, is that...
Sorry, is this something we're supposed to have been aware of and to have read?
No, I appreciate that. That's right. Nobody would have told you it was there. It was there. MOS 42 was to do with the application to get the materials in SUP 4 in, explaining why they were relevant. And Apple felt it necessary to respond to it, even though we were agreeing. Let me just tell you what I understand their position to be now, and they'll tell my lords if I'm wrong about that. I understand their position now to be that they do not suggest the judge was inviting or contemplating submissions on the substance of his methodology, but they draw attention to the fact that as a matter of law, it is always possible to seek to persuade a judge to reopen the contents of a judgment. And that is the substance, as I understand it, of paragraphs 9 and 10. I don't even know if they're saying that we should have done here.
Even if that's an option, it can't possibly be suggested that that's what you're obliged to do. The primary remedy is appeal.
My Lord has my submission. Now, the last bit on this, I don't want to go through the numbers, but we have provided, my lords, with some numbers that you get from Google and Qualcomm, and if you start doing averaging and so forth in Annex 2, they're just there so that you can see the kinds of things that you get if you start looking at both of them together. You'll appreciate that my primary position is it should be Google because that's the license under the portfolio, but the only other license that's of any use at all is Qualcomm because all of the others are tainted by holder out. Now, my lords, I'm pleased to say that is the end of my note on grounds 2 and 4. I am a little bit worried about time, and as a result of that, I think I've picked up everything there is to say about ground 1 and the overarching errors that you see, the fundamental principles. I don't think there's anything else that I can add to what I've said already, so I only had a very short bit in my note, but I'm going to move, if I can, to deal with points on the draft judgment next. And that is addressed in the section starting on para 260 of our skeleton. And our complaint here is that the judge came to his conclusion based upon very serious errors, indeed including what can only be described as catastrophically bad ones. And when the true position was pointed out, the judge was anchored to the views he'd already come to and expressed, and simply stuck to them when he should have had regard to the impact that correcting the errors that he'd made ought to have had. And this is completely opposite to the Robinson case relied upon by my friends, where the judge overlooked a part of the correct approach in that case, at least arguably, and as a result of it being raised with him after the draft judgment had been prepared, he reconsidered, and as a result, he actually altered the outcome of the case. That was a case of a judge who certainly wasn't anchored, and whilst the error in the initial judgment was very regrettable, it was the right thing to do to change the judgment if he was satisfied the draft was wrong. Here we say the judge in substance did exactly the opposite. And can I illustrate my point by just looking at 3 of the points we set out in paragraph 263. So I'm going to confine my submissions to looking at the matters identified in subparas B, D, and I think it's E, is it? Somehow I've told you it's 3, but my note only gives me 2. It is E. Yeah, E. It is E. So they're on pages 124 and 125. And because I've just been on it recently, can I start with the last one, E? It relates to the cross-check that we've just been looking at. The judge carried out that in the draft judgment, recognising that small portfolios were ones where the error was a particularly sensitive matter. He carried out the exercise that I showed you. In the draft judgment, the point of the exercise was to show that the royalties we were suggesting from our comparables implied an overall royalty payable for the entire universe of SEPs that was completely unreasonable. But when it came to it, it showed the opposite.
Have you really dealt with the substance of B, D and D already?
I have, yeah.
So it's just a question of
Well,
what you infer from those points.
it's the same point in every case, really. The Qualcomm one is maybe a slightly different one because he obviously just didn't stick precisely with what he did. He just found another number that did something just as good, or in fact was a bit worse. But the problem, my lords, is this: the judge has come to a view on a very mistaken way of looking at things, which, when he's corrected, ought to have had an effect on the judgment. Take, for instance, the past sales, where he was looking to see what in fact happened in those licenses, and he was applying what he thought had in fact occurred. When it was pointed out to him that the numbers were wrong, he decided not to do what would have been necessary because of what in fact occurred, but to give a completely different reason. And that is anchoring. That is basically sticking to a decision and then finding some other reason to justify it afterwards. And that can't be the right way in which judicial decisions are made. And in fact, it's quite striking that there's a passage on anchoring elsewhere in this judgment, explaining what the problem is. It's not without irony. And so we've obviously explained why all of these particular points are wrong, but in addition, we complain about the way in which they are arrived in the draft.
Yes, but this goes to the point, doesn't it? Because what actually is the ground of appeal? Because insofar as the conclusions in the final judgment are wrong, you don't need the draft. Insofar as the process by which the conclusions in the final final judgment were arrived at was procedurally unfair, again, you don't need the draft. Although perhaps maybe you say that the draft is part of the process of procedural unfairness. But apart from the final conclusions being wrong and the process being procedurally unfair, is there some third basis of appeal?
Yes, anchoring is an independent one in the situation where something, I mean, obviously if you're with me on them being wrong, it doesn't matter. But there are some judicial decisions which are within the scope of discretion, as it were.
Or assessment.
Assessment. And there are some judicial decisions which I might not be able to show are wrong, but if you can show that they were reached like this, I say they're challengeable because they're not actually for the reason that is given. Now, I totally accept, my lord, that if you're with me that they're wrong, then it doesn't matter. But if you're not, I still have that further fallback argument that they weren't actually reached for the reasons that were given.
Well, let's consider that. I can understand an argument that says looking at the draft judgment assists you to demonstrate the fallacies in the reasoning when you get to the final.
Sure.
But nevertheless, the ground of appeal is still that the final is wrong. And again, I can understand the argument that says looking at the draft illustrates that the whole process was procedurally unfair. But you're still maintaining that there's some independent ground of appeal, and I'm a little struggling to understand why.
Well, let's say, take the Qualcomm thing, where a different number's been used. I mean, I don't say that this is the right analysis, but if it's suggested that I somehow lose on some burden of showing that it is not open to the judge to have come up with a number like that, it is still wrong in my submission for a number that's very similar, perhaps a bit less, to have been arrived at, when in fact the judge, what he really had decided to do was to put in the full number, and he's just looking for a number to stick with what he originally put in. And
I mean, that expresses it in a very unflattering way. I mean,
yes,
yeah,
and I've
you're-
tried.
the,
There are areas where
possibly a
I've-
more attractive way of putting it is that it's sort of quasi-bias.
Yeah.
It isn't that you think you're doing anything wrong, but there's the potential for you to be overly attached to where
The
you started
appearance
off.
of bias.
Yeah, it is, and anchoring is that.
Yeah.
Anchoring is that, and anchoring, and actually the appearance does matter in this case more broadly. Trying to explain on this side of the court how this could have happened, trying to explain a lot of these things is extremely difficult because of the appearance. Well, as I've got,
And apparent bias is a recognised ground of appeal. And it is a bit different to other forms of procedural unfairness.
exactly, anchoring is an aspect of that.
Yeah.
Can I move on to the American proceedings? And it's quite a big topic to cover, but I can certainly outline the issue and how we got where we are.
So this is grounds 23 and 24.
Well, it's actually a little bit more than that. One of the things, it is those grounds, but also ground 14 comes in here. It's not limited to the US proceedings.
Before we get into the detail, can you give us a quick update as to what's happened in the US, if anything?
I don't think anything more than we've already said has happened. No, nothing more than...
No further developments.
No, because I think the reality is we can't do anything unless we come back and ask for further permission. Right, there'll be a hearing date, and then we can't go unless we go back to the judge because of paragraph 6.2, which is, we say, is an effect of an anti-suit. But I'll outline that.
Thank you.
So it is grounds 23 and 24, but actually you've also got ground 14 in play. Actually, I don't need to outline that now because I think my friends accept that it's within my permission to appeal. There was a ground in their skeleton.
Correct.
That's right.
Yeah, they do. I'm skipping over some stuff in my note because there was a contention in Skeleton that I wasn't entitled to run the appeal, and they've now accepted that it was because it was quite plainly in the Skeleton file for the Commission, and it comes in under ground 14. Now, what has arisen here is that there's a raised judicata judgment in the US in respect of 5 US patents. Very substantial costs have been spent litigating that. It's in the tens.
Sorry, but this is part of one reason why I asked the question. You characterise this as a raised judicata judgment.
Yeah.
But I'm uncertain in my own mind whether that is correct, because to be raised judicata in its true and full sense, all appeal rights have to be exhausted.
Well, it's
And
not
it's
that.
not clear to me that that is the position.
No, it's not that. It's, as I understand it, it's formally raised judicata because it's got through, but it hasn't had an appeal. So I'm going to explain that.
So it's final as a judgment,
Yeah,
but it's not
exactly.
appeal exhausted.
And I'm going to explain what
Yeah.
the status is. And so I'm certainly not intending to suggest to my lords that there's no appeal. You know that there is, and I'm going to explain where we've got to. It is formally raised judicata, as I understand it, in that it's final, but it is subject to an appeal. And because that is an appeal, we've cross-appealed, and that appeal has been fully briefed. So there's just a short oral hearing to take place, so with very minimal additional costs. But up until now, huge resources, not only of the parties, but of the US court system have been expended. So you've got that on the one hand, and of course there's also the global licence being determined by the UK court on the other hand. And I'm going to come on and explain how the situation arose shortly. And when I do so, my lords will understand why we say that's a situation entirely of Apple's making. But can I start by pointing out that this is nothing like the cases where there may be parallel proceedings brought by a SEP owner, say in Germany, which may be perceived as an attempt to use an injunction threat to bring extra pressure to bear on an implementer to agree SEP owners' demands early and therefore before any determination of what's FRAND. That kind of case, if that be the motivation, an attempt to have no determination of FRAND at all, because the point is for there to be an agreement struck before the UK determines FRAND at a level more beneficial to the SEP owner. So the duplication in proceedings in that situation is actually directed to avoiding any determination at all. Similarly, our position is not like the cases where parallel foreign proceedings may be extant in the sense that they've started but not decided, where it may be uncontentious that the willing licensor and licensee would agree to terminate those proceedings and deal with the infringements which have not merged with any raised judicata judgment under the licence to be determined in those cases. And in those type of cases, there will only ever be one judicial determination as to the value. Here, we are addressing a situation where there are in fact two decisions, or there will be when this court determines the licence here. We have a court of competent jurisdiction having already determined the sum payable for all past and future use of the 5 patents. And the specific question is how the willing licensor and licensee would address that in this licence being considered in our proceedings. Or, and this is absolutely key, my lords, if there is more than one way they might reasonably address this issue, what are those ways? And I draw specific attention to that point because of the third point that I picked up in the Unwired Planet judgment when we had it open. If more than one approach is reasonable, the set owner gets to pick.
I'm sure that my Lord Justice Arnold has said the same thing in other cases.
Yes, he has. And I must emphasise that it's not our contention, and never has been our contention, that there should be double recovery. Double recovery means being paid twice for the same acts under the same patents. So avoiding double recovery means not being paid for those same acts and patents under both the US judgment and the UK settled licence. But, and this is really important, avoiding that double recovery does not mean being paid the lowest amount that it's logically possible to construct under two valuation regimes. And just to be clear, that is precisely the point of the entire thrust of Apple's argument. That, as I've submitted, is not the same as ensuring no double recovery. And my lords, at this point, can I just point out a really important point for you to grasp, and it's this. Broadly, there are logically two ways one can conceive of avoiding double recovery where one has a situation like this, specifically where there are to be two determinations. The first is for both determinations as to value to coexist. If that were to be the case, one can avoid double recovery by one determination taking account of the other. There are different ways you might do that. For example, one may simply do it by the sum payable under the other judgment being taken account of such that you give credit for and only receive the excess sums. Or you could do it with greater sophistication by perhaps seeking to adjust the valuation in the second determination so as not to include monies payable for the specific patents or patent families which are subject to the other determination. In much the same way as the judge did as regards the valuation extending to ex-Ericsson patents in this case, he then adjusted to take it out. The possibility of adjusting to prorate in that way is obviously a possible way of avoiding double recovery. So there are ways in which you can do it that way by the second assessment taking into account the first and the two of them coexisting. The second logical way to approach the issue is for one or other of the determinations to be set aside. For example, in this case, the US judgment to be vacated or set aside. And in this case, that would amount to compromising the appeal and cross-appeal, and the agreement also being for setting aside the existing judgment. In that case, as I shall show you, Apple argue that how a winning licensor or licensee would approach valuing, compromising the appeal and setting aside the judgment might depend upon expert evidence as to prospects of respective parties' positions on appeal and so on. And they seek to suggest my clients are amiss in that by not having it, but startlingly, not Apple for not having it. Apparently it's okay to assert it will be given up for free, but any contention that there would be value attributable requires this kind of evidence. However, what is very important to appreciate as regards to the two different logical categories of approach is that the first, the parties agree to let the appeal run its course so as to get the final damages award in Texas, and then take that into account in the valuation determined under the licence settled here. So they coexist, you get the final damages and it's taken into account. In the second type of approach, one stops the US proceedings in their track. There never is a final determination because the appeal is compromised and the existing judgment set aside. And a consequence of this distinction is that in the first category of approach, one doesn't have or need evidence as to value of compromising the appeal, because the arrangement is to just let it happen, get the final damages award. You spent tens of millions of dollars in America litigating, and it costs practically nothing to just let it finish to the end. And to be absolutely clear, my lords, we say it is very important to have very clearly in mind what one is talking about when we're considering this issue. Is it the first kind of case or the second? Now, I trespassed on my lord's patience yesterday. I realised I went on too long, and I've got to what might be a convenient moment.
Do you think we're essentially on track?
I hope so. I'm going to cut down what I've got. I've only got to finish the US proceeding.
Yes.
Then my friend has got some submissions to make, but we, as I said to my lord yesterday morning, hope to be sitting down with a little bit of time left before the morning, so that we then get that on Monday as a reply.
Good. In that case, 10:30 in the morning.
Just before rising, may I make a modest request? There's been a confusion. The note on MOS 42, and it's entirely our fault. I would ask if the court could perhaps read that overnight.
Yes, I see.
We saw it as a responsive supplemental skeleton to the MOS 42 witness statement, which is a 17-page document, which is largely argument. I shan't go into that. It's just to say that some of the material in that short note is covered in some of the submissions that have already been made, so it will be efficient and speed things up if you do read it before I start.
We'll take that with us.
Say 10:30.
It's supposed to be 10:30.